Good afternoon. Welcome to Liticast. I'm John Robinson, joined today by Shari Belitz from Belitz Communications. Hi, Shari. Thank you very much for joining us today.
Thanks so much for having me. Pleasure to be here with you in my kitchen, the room with the best lighting everywhere and the best Wi-Fi.
Where are you joining us from today?
I am in West Hampton Beach, and I really hope you don't meet my kids. They're great, but I'm hoping you don't meet them today. No one needs to meet them.
I have been successful thus far in these Liticasts, keeping my children locked out of my makeshift office in my bedroom. But you never know. You might see a 2-year-old or a 5-year-old run across the screen or hear in the background through the microphone. It's okay.
That would be great. I'd welcome it. Exactly.
We're here today to talk about what you actually recently wrote a guest blog post about for us on litify.com about cognitive biases in the courtroom. Very interesting piece for those of you who haven't read it yet. Shari, we were talking about this about a month ago, and you put the content together, and then the intent was for us to kind of follow up, go more in depth about the topic here, and really give some tangible advice that some of our viewers can use on how they can both leverage cognitive biases as well as avoid it on their own right. So I think before we actually get into the meat of the topic, I think it would be helpful for those in our audience who don't know who you are, just to give a little bit of background about who you are and why you are the expert on this topic today.
Sure. I will give you the abridged version because I know we have a time constraint. I can talk to you about hours about this. So just to give you a little bit about my background is I was a psychology major. After major fights with my parents, I became a psychology major because I'm obsessed with the study of human behavior, of group dynamics. And so that's what I studied at the undergraduate level. I went on to law school after in the 1990s and started practicing law in the late 1990s at a small firm in downtown Manhattan. So while I was practicing through the 1990s and kind of the early aughts, I was put on a case, very ironically, in early 2001 that had to do with the World Trade Center. It actually had to do with one of the companies at the World Trade Center. So a lot of our depositions, a lot of time was spent at conferences in the Trade Center up and until 9/11. So 9/11 happened. My building that I worked was a couple of blocks away. So sounds like a cliche, but it was really a time of great reflection. It was a time of introspection for me. And I loved my law firm and I loved the people, and we were all young and fun and going to happy hour at the Divine Bar. If there's any New Yorkers who practiced in the 90s, you'd know that bar well. But I just it was like a turning point for me, and I knew it wasn't what I wanted to do with the rest of my life. I didn't envision myself to be at that law firm in 5 years, in 10 years, or really to be practicing law at all. I couldn't get psychology out of my head. So what I did is I formulated a plan, and I said, I am going to go to a corporate job where there are more structured hours, and I'm going to just take a leap of faith. I'm going to go back to school at night and study forensic psychology and jury research and all of the things that really fascinate me, and with my eye on becoming a trial consultant or a jury consultant and really marrying the intersection of law and human behavior. So fast forward, I took like 5 years to have fun at my corporate job with some great hours. And then I went back to school at night in 2006 at John Jay. Again, any New Yorkers familiar, fabulous program. And I must say, not only did I get to take the jury research and jury science classes, but I got to take classes on eyewitness identification. I took classes on how to give the Rorschach. If you ask anyone at AIG, which is where I worked, anyone in my department was given the Rorschach at lunch. They were all experimented on and given the Rorschach. They will tell you war stories about my armchair psychology stint during lunch hour. I took a semester's worth of classes on psychopaths. It was just a fascinating time in my life. The only thing better than the classes were my classmates. I was classmates with a hostage negotiator. There was an FBI profiler in one of my classes at John Jay, and it was fantastic. So anyway, years later, it wasn't until years later that I actually got into trial consulting, got into that, loved it, living the dream. Then here we are, another world event, COVID. I know we're all sick of talking about it, but again, like 9/11, it was a turning point. I said to myself, what do I love about my job? I love educating lawyers about social psychology and how they could use it to achieve favorable litigation outcomes. And I said, you know what? This is my pandemic project. This is my Corona baby. And this is what I'm going to do with my life. And I wake up happy every day, and I never go to sleep at night because I'm constantly thinking of ideas. So it's been fabulous.
And you've been producing some great content. That's how we originally got connected. I read one of your articles. It's great. Where can our viewers find you on the internet? Where can they read more of your content?
Okay, well, I kind of have an addiction problem with LinkedIn. So when in doubt, you can find me on LinkedIn. I always have that screen open. But if you really want to read my substantive content, my website is Shari Belitz, SHARIBELITZ.com, and join my mailing list. And, I don't want to make this an infomercial, but there is some great information there.
You do have a great LinkedIn following. I must say, probably many of them watching us live right now on LinkedIn Live.
So, hi.
If you are, please go ahead and post in the comments, whether it's on YouTube Live or LinkedIn Live or Facebook Live or on our website. Just go ahead, post any questions, say hello, let us know where you're watching from in the comments, and we can pull those up here on the screen.
And throw me a hardball. I'm all about it. No easy questions here. I'm prepared.
So we talked a little bit about how you got into social psychology, but why specifically should lawyers care about social psychology?
Okay, lawyers should care. Social psychology is critical because social psychology guides our human behavior. It guides our decision making. Now, just a couple of words for the audience's benefit really is, so I asked John when we were talking, I said, what's your audience look like? Because sometimes I tweak things. I often, because of my background, I'm talking to defense attorneys, I'm talking to insurance companies. And John said, you know what? A lot of our audience is plaintiffs' lawyers. And I said, great, because I love plaintiffs' lawyers because you guys, you understand social psychology, you are harnessing it, you have come up with the reptile theory, and your verdicts have gone on a trajectory since 2009. You were using anchoring in the courtroom, you were using anchoring during negotiations. So back to why it's so important. I think a lot of the audience will know it's so important because on the plaintiff side, it's going to drive up your verdicts. You've seen it. You've seen empirical studies that it is driving up your verdicts, understanding social psychology. On the defense side, who, in all fairness, I'm usually talking to, and I probably have a couple of friends in the audience, on the defense side, you are going to want to also be aware of the biases to mitigate them and to kind of lessen what they are doing. So it really, so I come here neutral to show you how to either exploit, and I don't mean that in that negative connotation kind of way, but really to harness the cognitive biases if it's going to help your case, and to mitigate them if it's going to hurt your case. But awareness is definitely the first step, either side. But I love talking to plaintiffs' lawyers. And if I have 2 seconds, I'll just tell a quick story. There's a plaintiff's lawyer in California. He puts out a lot of YouTubes. I love watching it because he just knows how to talk to a jury, and he knows how to talk to people. And one of the things he does is he visits his plaintiffs. He visits his injured plaintiffs and does a day in the life and really sees what it looks like to, whether it's getting down the stairs or eating breakfast, or do they have to go into a car or interacting with family members. Like, what is it like to live a day in the life with whatever types of injuries? And I think that's brilliant. And I think that's harnessing social psychology and really understanding human behavior. So I just wanted to throw that in. I think it's smart.
So social psychology in the courtroom, you see it a lot as the effect of cognitive biases, right? And there
Correct.
are different types of cognitive biases. What are cognitive biases, if you had to summarize it?
Okay. Well, I like to personify things because I think it makes it fun and it helps me remember it. And I would do that as far back as law school. But I look at cognitive biases as they're your little gossipy friends, and they're always trying to ingratiate themselves with the brain. And they're doing it by giving the brain gossip. They're giving the brain quick, faulty, juicy gossip. And you know what? It's wrong information. It is quick information. It is thinking intuitively. It is not thinking logically. It is mental shortcuts. In psychology, we call it heuristics. And that is what a cognitive bias is. And it's actually quite a normal thing. We use this in our everyday lives. It happens in medicine. It happens in politics. It certainly happens in law. But it's really the brain's way of making sense of a complicated, chaotic world. And it's anthropological in origin. But I just kind of like to make it like this little gossipy thing that always has the wrong information.
I have something that I always think about. Right? In the absence of information, people make stuff up, right? And the way that you make things up are more than likely through these types of cognitive biases. You're taking into account either a recency effect or prior experiences, and your brain is processing what's going on and trying to infer the situation, make sense out of it, right?
Spot on. That is spot on. You're using what you know to make sense of the situation. Absolutely.
In the guest blog post that you wrote for us, you talked specifically about their role in the courtroom. That's really what everyone watching today is interested in learning more about. Can you share a little bit more about the biases that you spoke about in the article and how they can be spotted?
Sure. Okay. Well, my bias is I like to start with a snappy title and draw people in. So once I thought of one, I just said, okay, we're going to write the article from there. So that's my personal bias. And that was, when is a taxi cab, or when is an elevator more dangerous than a speeding taxi cab? So I went back to a story that I had read a lot about in the news last summer, which it's so funny how time has changed. But on the cover of, in August 2009, the cover of the New York Post, the Times, New York One, everywhere you looked, there was this terrible story. It was, and New Yorkers will recall this, there was a gentleman 30 years old. I think he was on his way to work. He walked out of his apartment building. He was in his elevator, about to step out of his elevator. His elevator started bouncing. There were other people in the elevator, kind of like a very big fear of New Yorkers. And he stepped into the threshold and the elevator started bouncing more. It pinned him against the wall and it crushed him to death. And this story was all over the news, August 2019. And I remember seeing people interviewed on television and in the newspaper, and New Yorkers were terrified. This was the most terrifying thing going on in New York, how things have changed in a year. But people were afraid to get in their elevators. There was a pregnant woman who was saying she climbed 20 flights of stairs because she was terrified to get into her elevator. So as I'm reading this story, I'm thinking, what is the real threat in New York? And I know you're a New Yorker and I've been a New Yorker for many years. What is your real statistical threat in New York? Your real statistical threat is walking out into the street, probably distracted on your cell phone, and getting hit by a car or by a cab or by a bike. That is your statistical threat. But you didn't hear anyone saying, you know what, I'm not leaving my apartment. I'm afraid I'm going to get hit by a cab today But you heard people saying, I'm afraid to take my elevator. I'm walking down 20 flights of stairs. So that is your perfect example of something called the availability bias. And the availability bias, that's that mental shortcut when it sees something catastrophic, when it sees something unusual, when it sees something recent, it is going to kick into high gear. So that's the availability bias. And then I wanted to translate how it can be used in a courtroom. And I wanted to give a neutral perspective. I wanted to tell plaintiffs' attorneys kind of what to do with something like that if you got, and it was filed, it is a case. I don't know what happened with it, but let's just take a similar case. And let's say you're the plaintiff's attorney in that case, and you have something like a really freak kind of accident, but you have people very rattled about it because it's so unusual, it's so recent, and it's so shocking. So if you're the plaintiff's attorney, the availability bias is your best friend. And what you're going to want to do is you're going to want to set your case up to make a danger to the community argument. And anyone here who's familiar with the reptile theory will know that danger to the community is one of the elements of the reptile theory, which, just to go over, is defendant's conduct violated a safety rule, caused a danger to the community, and you, the jurors, put yourself in the shoes of the plaintiff because that could have been you, but for. So this elevator company, this maintenance company, this management company, whoever was sued, they caused a danger to the community. You can arouse the fear, arouse the anger. We're not talking about sympathy. That was the old way to present a case. We're talking about arousal of fear and arousal of anger, which comes from that reptilian portion of the brain, that amygdala, cerebellum, very ancient part of the brain. However, usually I'm talking to defense attorneys, and what I say to defense attorneys when I give them the same set of facts, I said, you are going to make an isolated incident argument. This is an isolated incident. This is terrible. This is tragic. A young man lost his life, but this is not a danger to the community. And you're going to show it with statistics. You're going to show it with your expert. You're going to show it with graphics and show them terrible accident, isolated incident, and take responsibility. Taking responsibility is not the same as admitting to liability. Take responsibility and diffuse that anger. So there you go. That's the availability bias I talked about in the article. And that's kind of both ways to approach it, because I want to come in here neutral and sort of talk to both sides.
You also talked about another bias, and you referred to it as falling in love with your case, and how it could that could potentially affect negotiations, affect eventual outcomes for the client. Can you talk a little bit about that and the bias that is causing that?
Absolutely. So that is called confirmation bias. I like to call it falling in love with your case, because I talk to defense attorneys most of the time. I say falling in love with your defenses. And that is actually the most prevalent and the most detrimental type of bias, but it's also one of the easiest to fix. So confirmation bias, think about it. You're going to have it. Everybody has it. Everybody has it in every aspect of their life. But you're in a courtroom. The lawyers are going to have it. The litigants are going to have it. The judge is going to have it. The bailiff's going to have it. And the jury's certainly going to have it. However, who is the easiest to work to defeat confirmation bias? Yourself, the lawyer. You are going to be able to start with yourself. You start with yourself first. You go to the jurors second. Not much you can do about the judge. But so let's talk about ourselves. So we are lawyers, and I was an insurance coverage lawyer. Not the most passionate kind of work, I will tell you, but to do good work, from the time you get the complaint or the time you file the complaint, you're going through then your written discovery, your interrogatories, you get up to the depositions, And that piece of discovery, maybe there's negotiations, then there's motion practice. So anyway, throughout this process, you start to fall in love with your case. And it is absolutely the most normal thing you can do. And it's also the right thing you can do as an advocate. Like, I would go argue these extremely boring motions, like an insurance company versus a bank, but I'd have to be passionate. I'd have to have my advocate's hat on. I would have to believe in my case, and to do my job, I'd have to fall in love with my case. However, your advocate's hat is in direct conflict with your neutrality hat. So, and then there's, I don't want to throw too many psych terms out, but having your advocate's hat, which you are an advocate, first and foremost, in conflict with your neutrality hat, you're experiencing something called cognitive dissonance. And people do not, it's a human tendency. I remember learning about this in Psych 101, which kind of made me fall in love with Psych 101, is people don't like having their behavior conflict with their thoughts. So if you're an advocate, you do not want that behavior conflicting with your thoughts about the case. It's just a natural unconscious bias thing that happens. So again, I have a lot of defense attorney clients, and a lot of times they will have cases where there's a violent third-party act on an insured premises. I think this is a perfect example, because in these cases, whether it's a shooting at a bowling alley, whether it's an assault in the parking lot or a hotel, you have cases that are very questionable in liability. I think they're very defensible in liability a lot of times. You have some third party come in and like shoot up a place or attack someone. So really you have pretty decent defenses from a liability perspective, but you also have shocking damages that shock the conscience. And when I see a defense attorney falling in love with their case, well, you know, we had great lighting and we had, like, you know, these state-of-the-art cameras, and there was a security guard over there somewhere. Like, we're good. We can defend liability. Maybe so, but you have damages. You have an 8-year-old who was shot, or you have a 15-year-old who was assaulted. Don't fall in love with your security cameras. Don't fall in love with your security guard who was milling around. Go look at your case objectively, and I'll tell you how to do that. I'm kind of like on a monologue, so if there was any questions that you had, I can kind of give you the how to ameliorate and mitigate that.
No, this is great, right?
Okay.
To boil it down, confirmation bias is overvaluating your own argument and undervaluing the argument of the opposition. Is that fair?
That is 100% fair.
What's interesting about cognitive biases is they don't live in a vacuum. Very often they're layered, correct?
Correct.
You can have multiple that are affecting you at the same time, and sometimes in contradictory ways. And in the absence of information, or in information overload, your brain processes and gives you some sort of binary outcome because you have to speak or you have to behave in a certain way. You know, something that's similar to confirmation bias is choice supportive bias, right? Where people are tending to feel good about the decisions they've made in spite of the flaws, just because it's a decision that they made on their own, right? It's this.
Absolutely. It's and it actually reminds me a bit about cognitive dissonance, where you don't want your behavior. People have an internal conflict when their behavior conflicts with their beliefs. So they will jump through mental hoops to have their behavior in line with their beliefs. So that's an excellent point, and it plays out in real life all the time. So great point. Yeah, the biases can overlap, certainly.
How would you recommend someone self-identify that they are being affected by a bias versus thinking clearly and objectively?
Okay, so I would say with respect to, let me give you a general example and then I'll
Sure.
give you a litigation example. I like using politics as a general example because people have major confirmation bias with politics. So gazillion years ago when there were gazillion people in the Democratic primary, I had a favorite. This favorite is no longer a contender, but I had a favorite probably because of exposure bias. This is who I knew the best, grew up, same home state, remember his whole career trajectory. Know a lot of people who worked for him, his campaigns, know him personally. So I was a huge fan of this particular person and wanted to see him take it all the way. But anyway, that was exposure bias. And I was not checking my exposure bias. I was letting confirmation bias get the best of me. Anything positive I would hear about him, I would internalize that and say, yeah, of course, that's the kind of person he is. Of course, look at how great he was at this fundraiser and he brought his mother and he's like a fantastic, upstanding person. And look, it's confirming all my beliefs. But then if I would hear something negative about this person, I would kind of make an excuse in my mind. And, just full disclosure, not getting political here, but I'm from New Jersey. This is Cory Booker. And if I would hear something bad, like, oh, the pharmaceutical companies, or, oh, he loves Goldman Sachs, I would just, you know what? That's New Jersey. Everybody's somehow affiliated with the pharmaceutical company. So I would make excuses instead of actually doing my research and reading. So that in real life is confirmation bias and a little bit about my politics. So how does this work in the courtroom? Lawyers need to know their confirmation bias. They need to know if they're falling in love with their case, if they're falling in love with their defenses. And the best way to do that, the pristine gold standard, is obviously the mock trial. And I know the plaintiff's bar is doing a lot of research, doing a lot of mock trials. And I'm not trying to sell you on that at all because I think there's other ways to do it. But I will say with the mock trial, and we've done, I've seen tons of them for the defense. You will have two lawyers from the defense firm arguing both sides. The one who argues the plaintiff's side will always come up after and say, I have learned so much about this case. I have learned so much about my side. I've learned so much about my weaknesses. So what I would encourage, and again, you might not have the budget, you might not have the time, you might not have the approval, but argue the other side, whether you're arguing the other side with a colleague, whether you're arguing the other side to a mirror or writing down your weaknesses, their strengths. Get inside their head. It's not the time to be an advocate. You're not in the courtroom arguing emotion. You need to find the flaws in your case, and that's how you're going to defeat confirmation bias and really understand the other side.
I think that's fantastic advice. Basically, break your own argument. Prove yourself wrong, right?
Absolutely. And you know what? In life too, think about it. So much of the news that we consume is confirmatory to our positions. And I sometimes like to kid around, and I used to say, okay, you're very, very liberal. You know what? Go put on Fox and just hear what they have to say. You're very, very conservative. Pick up the New Yorker. See what it's about. Pick up the New York Times. So it's really, and I have conversations with someone, it's a good friend, it's a colleague. We're very politically on different ends of the spectrum, but we're both respectful. And I learned so much by listening to his arguments, and I try to really understand them so I understand myself better. So it's really an exercise in human behavior that can be used in or out of the courtroom.
Yeah, I think we're safe to say that the social media vacuums that we all live in have put us in a constant state of confirmation bias. The
100%.
Algorithms are built to
100%. And it's oh, go ahead.
No, I mean in that case, it's all driven by getting you to view certain ads or click through on certain things. But it's become the norm, right? So
right.
we are now living in a world of confirmation bias.
Absolutely. And it's really healthy to step out of that world. And I don't want to go on too much of a tangent because I know you have a bunch of great questions, but there's an organization I read about a couple of years ago, and they brought people together on opposing sides of major issues. Like there was someone who lost a child to gun violence and was very pro-gun control. And then there was another person who was NRA, very pro-Second Amendment, pro-gun. And it turned out he had a sister who was violently attacked. So they put the two people together to have a respectful conversation. And what came out of it was they were operating from that same fear. They were operating from safety. They had that exact same core concern, but they were approaching it in different ways. And a lot of it maybe because of, one grew up with a culture of guns or one did not. And I don't really remember the details, but I think it's really, interesting. And that's why I was so excited to talk to plaintiffs' lawyers, because I usually talk to defense lawyers.
Are there processes or forums or advice that you can give to attorneys who need to get an outside perspective to understand if there are unseen flaws in their arguments?
Sure. So as far as specific arguments, I would say really listen and learn and read what your adversary is saying, because that's their playbook. That, you know what, you do yourself no service by looking at their motion papers and saying, you know what, that's not true, or they're lying about that. No, really look and see. So when you're talking about a specific case, but what I like to do generally is to tell lawyers, and again, confirmation bias, I'm linked in with a ton of people, defense bar, defense organizations. I read all the publications. But you know what? I read a lot of plaintiffs' publications too, and I am connected with some plaintiffs' attorneys. Mostly it's like people from law school or people I knew way back. But when I started watching these videos of this great plaintiffs' attorney and kind of what he did, and when I started reading plaintiffs' publications, I could understand where they were coming from, and it's only going to sharpen your arguments, and it's only going to help you understand and help you talk to a jury if you're adverse to them.
So in the jury selection process, right, biases can come into play in a number of different ways. How can plaintiff attorneys specifically spot these potential biases during the process?
Okay, so my favorite bias to talk about in voir dire, and it is the most salient bias in voir dire, is something called the social desirability bias. And the social desirability bias posits that we want to, especially in a group, put our best foot forward. We want to give answers that comport with social expectations. I'm not saying there's not that outlier there who really doesn't care what people think. My dad was like that. He would just kind of like blurt out anything at any time. That was a little unusual, slightly embarrassing, but most people want to comport with, they eat better, they vote more, they spend more time with their children, they read more high-level publications. You want to really comport with social norms. So your biggest obstacle as the lawyer in voir dire is social desirability bias. That's your biggest obstacle in getting an honest answer. And because you're looking for other kinds of biases, you want to be able to circumvent that social desirability bias. And that's not going to happen unless you do the work, and unless you know how to do the work and how to talk to the jurors and how to strategically answer the questions. So I can give you some, whether you're plaintiff or defense, this is like some pretty universal advice if you'd like me to kind of.
Sure.
Okay, so the first thing, very easy. you want to normalize bias. You want to normalize it to a point that people don't feel inhibited. They know it's normal to be biased, and you can do it. You could do it with a ridiculous example. You could say, like if I was up there on either side and say, you know what, I think I'd be a great juror, but, you know, I'm a huge Yankee fan, and if there's a case about the Yankees, that's not going to be the case for me. I would not be able to be fair in that kind of case. I will be fair in any other case. A case about the Yankees, don't get me involved. And you probably shouldn't get me involved in the Red Sox case either, because I'm not going to be fair there either. So so that's like kind of a ridiculous babyish, and you're going to want to do it a little more geared to the case. Like, I can't be fair to a truck driver because someone in my family was in a trucking accident, like something like that. Normalize bias. Okay, second thing, this is something I tell defense attorneys. I think it's a little bit more important on the defense side. But remember, if you're on the plaintiff side, you kind of want to hear what's important on the defense side. So let's say a defense attorney is representing a large company that no one really has any sympathy for, whether it's, one of these big talc cases, one of these verdicts where you guys are hitting it out of the park. What you're going to want to do as the defense attorney is first participate, body language, raise your hand and say, how many people here sometimes think that companies put profits over people? Who here sometimes think companies put profits over people? So you're doing two things. You are getting involved as one of the people who may hold this opinion. You're raising your hand, you're getting involved, even though this is your client. And you are also using a hedge word. You're using sometimes, because, and that brings me to my next point, is asking strategic questions. Okay, so there are so many lawyers in voir dire. They're asking questions. Can you be fair? Can you be impartial? And social desirability bias is going to kick right in. Like how embarrassing to say, no, I can't be a good citizen. I can't be impartial, or no, I can't be fair. So by asking those questions, you're wasting your time. You're defeating the purpose of really teasing out the bias that's there, and you're not circumventing social desirability bias. So here's the best way to ask those questions. So let me give you the wrong way. The wrong way is absolutes. And if you're taking notes, I would write this down. This is like my one major takeaway if you're taking notes about voir dire. Absolutes. Can you put this aside? Would you assume? Could you be fair? Terrible questions. You are making people be on the spot, and you were asking them questions in absolutes. However, and there's been empirical research on this, there is empirical research and a lot of psychological literature. If you ask the questions in gradations, or using, as I like to say, hedge words, would you have some difficulty? Could you easily? Would you strongly agree? Would you slightly disagree? You're going to start to get some hands. You're going to start to get people who are going to really not feel inhibited, and they'll be able to talk to you about your bias. And then that's when you can really start to ask them the specific questions, but you can't do it unless you can find them. And another point where there's been a ton of research, a ton of empirical research, is if you ask about someone's ability, you are not going to get beyond social desirability bias. Do not focus on their ability. Do you have the ability to be fair? No one wants their ability questioned. Ask it like this: degrees of ability. Could you easily? Might you have some trouble? Yes, I might have some trouble finding a pharmaceutical company puts profits over people, because my family used to work for, we were company people at J&J for 30 years. And you want to keep pushing so you can get those strike causes and not waste your valuable peremptories, but that's how you're going to get to it. So dispense with the can you put aside, would you assume, can you be fair, because you're wasting your time.
These are great actionable pieces of advice. So thank you for sharing them with our audience. We have a question that came in, not through any of our social channels, but through our live chat on our website.
Okay.
Someone asked, if a plaintiff's attorney does not have a very high opinion of his case, can he or she still do a good job going forward with representing the client?
Okay, so there are a couple questions with that. So my first question would be ethically, and I think this probably comes up a lot in the criminal arena as well. Ethically, do you feel like you can give it your all? So that's like a total separate inquiry. But if you don't think the case is strong, and there are so many cases that are not strong from either perspective, I do think that you can. I truly believe you can. And I go back to my example of, so I was an insurance coverage attorney. I mean, who wakes up and says, you know what, I'm going to be an insurance coverage attorney. So, I mean, I didn't even know what that was. I wasn't even sure why they hired me. It was crazy. But so anyway, I remember I was sitting in New York Supreme, and the judge said, so-and-so versus so-and-so, an insurance company versus a bank. Boy, do I care. And, I kind of had the same reaction, boy, do I care. This wasn't an injured person. This wasn't David versus Goliath. This wasn't a criminal case. This was an insurance company versus the bank. But I said, I am here to argue. I said this to myself. I am here to argue this motion, which was probably a very insignificant motion because I was a first year, so I wouldn't have been given anything too significant. And I said, I am going to be the best advocate for this insurance company. They are not going to know what hit them. And I just delved in and lived my case and lived my motion. So I do think, in life, think of all of the things that I was homeschooling my kids. Do I like it? No, I absolutely hated it. Do I have to care? Pretend to care? I do, and I did. So I think it's kind of a life lesson. But ethically, that you raise a good question, and I don't know what the answer to that is. I would say if I couldn't zealously advocate for something, based on some kind of, I don't want to represent a tobacco company, or I don't want to represent someone accused of child abuse, that's another story. But you know what? You get some boring run-of-the-mill case that you don't think is great. You know what? Put on your best advocate's hat and advocate.
I'm going to make an assumption about the question that that this person is asking about the strength of the arguments, right? Mm-hmm. This is a case that they got, and putting ethics aside, that the case may not be as strong as they would like it to be. Some loose connections in their arguments. They're in the context of what we've been discussing today. It sounds like your advice here is to not let your mind play tricks on you, right? To objectively look at the case.
Objectively look at the case. And what I should say, and when I say that my company helps lawyers achieve favorable litigation outcomes, a favorable litigation outcome might not mean pushing something all the way to trial. A favorable litigation outcome could be an early resolution, hey, I'm looking at this case objectively. It's horrible. My witness did terrible at deposition. Everyone hates them. They're, not presenting well. This case is bad, and recognize that, and don't let your confirmation bias tell you not to. If your client or if someone is pushing you to go ahead, you do the best job you can, but you have to be able to be neutral and give that advice and say, you know what, this is a loser because X, Y, and Z, and I think the best resolution would be to sit down and see how we could resolve this amicably.
Yeah, great advice. Many cognitive biases out there. We've talked about a few of them here today. Even before we spoke, Shari, I remember there was an article that I read, and I remember the website that I read it on. So if anyone wants to catch up on this, just Google mental floss cognitive biases. And there's this infographic.
Okay. All right.
This infographic of 20 different cognitive biases, and they give tangible examples of each, obviously not directly related to law, but in your everyday life, there are biases that you are not even realizing that are affecting other people and are affecting yourself. It really helps you understand what's going on in your everyday experiences. Things like, we had talked about this right before we went live, clustering illusion, right?
Mm-hmm.
And you called it gambler's
fallacy.
Gambler's fallacy,
Mm-hmm.
right? So thinking that there are patterns in random events, and there aren't actually there, right? It just so happens that you hit red twice.
Right. Like you'll see it at the blackjack table, you'll see it at a casino, and you'll see it how people are betting, how they're betting in poker, if you pay attention. And in fact, poker is a really good study on human decision making. And Annie Duke, the poker champion, has an excellent book out about biases, and it's very interesting. I don't recall the name, but it's really talks a lot about human decision making and why she's been so successful in what she's done, and really like understanding that process of human decision making. So yes, gambler's fallacy, absolutely. And I can apply it to the courtroom as I see this all the time. This happens frequently in the defense world. I'm sure this happens in the plaintiff's world as well. But you may be getting a great outcome with, let's say, you have this shoulder expert. You love this shoulder expert. You're using this shoulder expert on all of those cases, and you happen to be getting a great result, whichever side you're on. And you say, you know what? I'm using the shoulder expert on everything. Well, you're deciding that based on the outcome, but there are so many variables that maybe it was the judge, maybe it was the jury, maybe it was a Friday and everyone wanted to get out of there. Like, you have no idea. And that's kind of tied in, like you were saying, with the layered biases, that's tied in with confirmation bias. Like, now you're in love with the shoulder expert because you're getting good results. And it may very well be that, but you need to look beyond that.
Yep. There are things like bandwagon effect or groupthink, especially when it comes to jury deliberations, that can happen. Recency bias, where people are weighing more recent information that they've received more favorably than older information. So there's a lot out there. Obviously, the world of social psychology is extensive, has far reaches beyond the practice of law. If anyone watching today wants to speak with you directly about your services, again, where can they find you?
Okay, probably the best place to find me is LinkedIn. Just shoot me a message and I will get right back to you. And also, I would say sharibelitz.com, my website. There's a place for your contact information. And if you want to take a look at some of the articles I've written, some of the videos I've done, podcasts, things of that nature, because a lot of them are about cognitive bias. So we could kind of continue the conversation like that. So I would say shoot me a message on LinkedIn and we'll chat, and that would be fantastic. I love hearing feedback.
Excellent. I want to thank everybody for watching us today, whether you're watching this recorded or you were able to join us live. Shari, thank you so much for sharing your insights. Thank you so much for your contributions to the blog, and for all the great content that you're regularly producing. We have more Liticast coming up. We're doing at least 2 of these a week. Check out the upcoming schedule on litify.com/Liticast. Tomorrow, Jared Correa is talking about chatbots, very different than social psychology. But anytime Jared joins us, it is a great conversation. Thank you again, Shari, for joining us, and we will talk to everybody soon.
Fantastic. Thanks so much for having me. This was a lot of fun.
Thank you.
Okay, take care.